Hello friends, in the series of income tax cases today we will discuss a case which is related to the cash seizures by various authorities like Excise Department, Police Department, and the cash which is seized during the election periods, and what is the power of the income tax department regarding this cash seizure when these departments inform the income tax department that this much of the cash has been found at the premises of the assessee. This issue has been taken by Kerala High Court in the case of RAVIRAJAN and others versus State of Kerala, and this matter has been reported in 471 ITR Act page number 131. The date of the judgment is 26th September 2023. In the present case, the cash of the assessee was seized by the Excise Department, and when this cash was seized, then this cash was deposited in the Metropolitan Magistrate Court, and this cash was given to the Income Tax Department by the order of the court, Court. For this, the assessee has gone into the Kerala High Court. There was no assessment proceedings pending against the assessee. There was no assessment done for the assessee for that year. So, it was the plea of the assessee that according to section 132B, that is for the adjustment of the asset seized for the tax liability of the assessee, section 132B basically says that the asset seized can be adjusted towards the existing tax liability of the assessee or any tax liability which has been created by doing the assessment. But if the cash has been seized by the Excise Department and that cash has been deposited in the court, then that court cannot give that cash to the Income Tax Department. This was the plea of the assessee. But in the present case, the Metropolitan Court under section 451 of the Code of Criminal Procedure has handed over this cash to the Assistant Director of the Income Tax by giving the directions that the assessment of the assessee should be completed in a less span of time. When Kerala High Court was hearing this matter, the court was of the opinion that in the present case, if the revenue want to adjust this cash for any liability of the Income Tax Department which is existing on that date, then that Income Tax Department has the power under section 226 subsection 4 to apply to the court. And since there is no existing liability and no assessment has been completed, then in that case the Court was not justified in giving this cash to the Income Tax Department. So Kerala High Court ordered the Assistant Director of Income Tax to return this cash to the Metropolitan Court, and then that cash should be given to the assessee. But one condition was imposed. That condition was that the assessee has to furnish a bond with 2 solvent sureties. In a number of cases, it has been seen that whenever any search is there by any department other than Income Tax Department and they found cash, or whenever the police found some cash in some checking, whether it is during the election time, then this cash is demanded by the Income Tax Department, although there are a number of the judgments that this cash should not be handed over to the revenue. And sometimes it happens that even the Metropolitan Court, Session Court also gives order for the release of the cash, but this matter got stuck in the High Court, and when this matter goes to the High Court, then this is a criminal matter, and in that case the assessee has to spend 4, 5, 6 years for getting this cash released. So there should be some straightforward law in the Income Tax Department for this type of events, that the assessee has not to suffer because of the lengthy procedures of the courts, and because in that cases whenever the cash is seized by the department or requisitioned by the department not as per the law, the business of the assessee suffers a lot. At the end of this video, once again I am repeating the name of the case. The name of the case is RAVIRAJAN and others versus the state of Kerala, and this case has been reported in 471 ITR at page number 131, and the date of the judgment is 26th September 2023. Thank you, friends.